In this short video, we're going to be taking a look at deceptive similarity as part of trademark law and how it was applied in the Henschke and Rosemount Estates case. Now, deceptive similarity is covered in the Trademarks Act of 1955 in Section 10 and Section 120. Section 120 states that a person will infringe a registered trademark if the person uses as a trademark a sign that is deceptively similar to that trademark in relation to the goods or services in respect to which it is registered. Section 10 goes on to define deceptively similar as where a trademark is so similar or nearly resembling another trademark to the extent it is likely to deceive or cause confusion. This case in particular dealt with two wine manufacturers. The original plaintiff, Henschke & Co., have been producing wine since the late 1950s under the name Hill of Grace. Hill of Grace is an extremely expensive and an extremely well-regarded wine. The defendant, Rosemount Estates, are also a long-time wine producer. However, at the time of the case, they had quite recently acquired a winery, a vineyard, and then a trademark for Hill of Gold. Consequently, they'd begun selling wine under the Hill of Gold name. Now, Henschke brought the case because they felt that Rosemount were infringing on the Hill of Grace trademark and that it was deceptively similar to Hill of Grace. They also thought that Rosemount were trading off the good name of Hill of Grace to sell their wine. Before diving into the application in this case, it's worth taking a look at the deceptive similarity test. It is a complex and detailed test and one that's been developed in a number of separate cases. There's quite a good summary of this test in the Crazy Ron's communication case, which I've further summarized here. We won't go through it in detail, but it is worth touching on briefly. Essentially, the test for deceptive similarity is not a side-by-side comparison. It's a question of fact for the court to consider whether there is a reasonable probability of deception. It is necessary to show tangible danger of deception, and the court must allow for the imperfect recollection of a person in determining whether the trademark resembles another trademark and is likely to deceive and confuse. Finally, authorities recognize that the concept of imperfect recollection applies to trademarks consisting of phrases, not just invented words. So, in the case, the court focused on the importance of the Hill of Grace reputation as a turning factor. They began by distinguishing this case from other cases, such as cases where Woolworths or Coca-Cola were the plaintiff, calling out another company or trademark for deceptive similarity. The court stated that while Hill of Grace had a strong and a well-known brand, it didn't have the same level of ubiquity as some of those other larger companies. The court then went on to say that the assertion by Henschke that all Hill of anything titles infringed on their trademark was incorrect and that would be making the scope too broad. They considered a number of names and using examples such as Hill of Goanna, they found that there wasn't really a need to prohibit all names that had Hill of in there from infringing on the trademark. They went on to consider whether Gold and Grace were so similar that Gold itself would be infringing on the trademark. They looked at whether people would look at Hill of Gold and assume that it was affiliated with or perhaps mistake it for Hill of Grace. The court found that while the two phrases were phonetically similar, the definitions and the use of the words gold and grace were not so similar as to make this a case of deceptive similarity. On this basis, the court allowed Rosemount to continue to produce and sell their wine under the name Hill of Gold.